we've got three very interesting questions, and the first question is around servitudes. So let's get into that one. The question goes, it says, my neighbor and I share a driveway. The neighboring property has a servitude in place, which enables them to use this driveway, to access their property and a riverfront. Now, the river runs by both properties. My neighbor has recently started using trucks to obtain water from the river. These trucks are causing substantial damage to the driveway which is shared. I've asked him to stop and then also to repair the driveway. He always, at all points in time, refuses to do so and says he has a legal right to use the driveway. My question is, what are my rights and what are servitudes and how do they work? Soma, can you provide some context here?
Happy to. Servitudes are actually a very complex part of the law, and it's a very interesting part of the law. And unfortunately, I have to take us back to way back when Roman times again, because this is obviously where it comes from. So let's quickly picture, if we picture life right now, it's difficult. Very often, a lot of the property law things, because our property law is still very much based in common law, or even if it was codified at a later stage, it is more basically codified on the original Roman Dutch law principles. And especially this part of property law is very strongly developed in Roman law. So picture, I need us to go back, like way back, like old Romans. So the guys in the sheets and the grapes and the you know, that old Romans. If you picture the landscape at that stage, it's not the buildings we see now. It's not Santon, definitely not. It is like very big open areas. And even in the towns, you had very big open spaces or very cluttered onto each other. So it's a very, it was a very interesting setup at the time. So let's picture the slightly more rural areas in old Roman times when the law was developed, when the Roman law was developed. Your neighbor might have had to use a road on your land to get to his place, because remember, I don't think the Romans really had town planners down to where we have it now, where they really thought about, you know, how are we going to get to where we need to be. So things happened and people started building or planting somewhere, and they didn't realize, I just said that, that's Latin, that's very high Latin. You have to cross my land to get to my milli field or whatever they were planting. I can't picture now what they were planting, but then this law was created. Now, practically, in the law we have right now, servitudes were registered all along, and our servitudes are registered by the deeds office, so by the registrar of deeds, and it is reflected on the title deed. So you will see in every title deed, whenever you transfer, the original servitude and the way it was registered against that particular title deed will still be exactly the same. I actually had a recent thing, so sorry, Team SSLR, I'm laughing at something that happened in the office the other day. We have an eviction instruction in Brits, but there's a servitude on this particular piece of land, and the property is obviously registered in the Pretoria Deeds Office. And one of the candidate attorneys came to me, English candidate attorney, and they said they had to ask my friendly PA to assist them to translate, but they realized this is not Afrikaans. What on earth is this? And I said, this is that, kids. This is what it is. So, sorry, that's the part where I'm sorry, guys, but it's Dutch. And they said, but what on earth is this title deed swinging from English to Afrikaans to Dutch? And that's the way title deeds works. That's the way servitudes are registered. Because at the time of registration in 1852, it was Dutch. And that servitude is still recorded in that exact same way until you either approach the registrar of deeds and change that purposefully, or you now might just carry on with that. My point with this is, if something on a title deed in South Africa today, in Brits, okay, that's not a good argument, but just hear me out. Sorry, Brits people. I'm just saying the chances of Dutch there is a little higher than most other parts of the country. If that is still in Dutch, the way the land looked and the way the land functioned is different from, 2021. It's a different landscape. It's a different era. It's a different way of doing things. To have a river and to move water with trucks wasn't an option at the time this particular viewer's servitude was registered. The trucks were probably not even a thing at the time, only like the richest rich people had it, and water were carried and moved in different ways. So you have different kinds of servitudes. One of the servitudes is a right of way. A different kind of servitude would be, for instance, a right of water. So you may lead water over a piece of land. That would typically be in agricultural purposes, where you have a dam on your one piece of land, and then there's neighboring land, and you need to get the water up somewhere else, and you build this is now where you see the farm girl is coming out in me. So you build a bit of a track for the water to run over the neighboring farm to your farm. And that's still very often used in our law to this day. And then there's a multitude of servitudes, and you always have one piece of land that's a serving land, and the other one that's the land that benefits. So in this particular case, we're only dealing with a right of way. Now, a right of way, it can be a very specific type of servitude. You may, and I hope you will, have specific limitations on your right of way. So your right of way servitude will say what is allowed would typically be, you as the neighbor may use this only for access to your property. If that is the servitude, to now drive water up and back and forth on this would not be allowed. So the fact that somebody has a servitude and a right of way specifically doesn't mean you can use that right of way as you please and for any purpose. So for this particular viewer, I would recommend one of two things. Either approach a conveyancer and ask them to draw the title deed. If you don't have it, get a copy of the title deed from the deeds office so you can see what the details of the servitude is. If it's simply a right of way that says you can only get to your place and back, a truck full of water isn't getting to your place and back, not at all. So it's as simple as then showing him a copy of very high Dutch and saying, once you figure this out, my friend, you will see that you can't carry water back and forth here. Or if that's not the case, you are definitely entitled to a damages claim because it is your property. And if the use of the right of way is causing damage to your property, I would first do a demand, a letter of demand, and I would give them a reasonable time period. Now, let's be fair, 7 days is not a reasonable time period to repair the damage. I will give them something like 20 days or 30 days to repair the damage. And if they don't, I will institute proceedings. If you have a servitude with limitations, so they're not entitled to use it for the water, and they carry on doing that, only option to resolve that problem is not, to go and key the truck or something. The solution is approaching a court and obtain an interdict to stop them from doing that. Bruno, is there anything that I left out? I even added keying the truck in just for fun. Popping the tires.
No, I think that covered it completely.
I didn't say popping the tires. I left that.
Thank you so much, Cilna, for that. We're going to move quickly on to the next question. And see, this has got an American context to it. So, Bruno, I read an article from America, and it talks about property wholesaling and contract assignment. I haven't seen this in South Africa. So, Bruno, please, can you shed some light on this topic? Do I have to repeat it?
It's very difficult to take this question seriously now. Thank you.
So let me start again. This is something that we're seeing, in American articles and books about property wholesaling and contract assignment. And we haven't really seen much of this in South Africa. So maybe you want to shed some light on that, Bruno?
Sure. Thank you. All right. So the basic principle here, if we forget all the legalities around it, is the concept of wholesaling is buying at one price, selling at another price. Right? You can do certain things in the meantime between the two sales to increase the value, but it is still a matter of buy at one, sell at another. And a contract assignment is the means by which you would actually do this. So in the US, you're allowed to go out, make certain offers to people, and then find purchasers somehow. So you can make offers to people to buy properties in bulk. So let's say you buy 10 properties from one owner at a fixed price, and you go out to market and you sell it to individual guys. In South Africa, the concept would be applied along the lines of sales and execution, for example, where there might be an anticipated reduction in market value because it's going up on auction, which carries certain risks. So a person buys it, sorts out the problems, and manages to sell it at a higher price to the end user, right? So this is the concept of wholesaling. It's carrying from wholesaler, you the dealer, and then the end consumer. So the problem that we experience in South Africa is the application of this principle and the legalities behind it, because how America allows it to take place and how South Africa allows it to take place are very, very different. So in the US, you can do this quite openly with very little interference from SARS, for instance, and regulatory bodies. Here in South Africa, the problem is that, for starters, everyone that used to do this in the past used to get away with it until SARS came in and started basically discovered or identified that people were buying properties, they concluded a sale agreement, and then all of a sudden they used to go and nominate someone to step into their shoes and take over the sale. And SARS's argument to this was, hold on, wait, you're actually selling the property to somebody else. So you're hiding behind the fact that you're nominating or assigning somebody else into the shoes of purchaser. So as a brief example, let's say I buy a property from X, and me and you get into a conversation and you like this property. And I go, cool, no worries, just take it over, sign here, and you step into my shoes, and now you've got a contract with X, and I walk away from this, right? Now, this used to be allowed, and then when SARS thought, hold on, but this is two sales that are actually taking place, and instead of SARS getting paid once their transfer duty, twice their transfer duty, we were bypassing them, and we were only paying transfer duty once because the sale would go directly to you. And this is when they jumped in and said that you're still allowed to nominate. So let's equate nomination to assignment, so that the US readers would understand. You're still allowed to assign, but it has to be before midnight of the day that you signed, concluded the OTP. But at that point, it could still be reasonable to do it. Any time after midnight would be seen as a second transfer. So you can still do it. You can still nominate and assign, but SARS will identify it as a second transfer, will charge transfer duty twice for that transaction. So just be ready. If you're going to assign, you're going to have to double pay. It's especially if you do it by way of nomination. So legally speaking, so a lot of people do very dodgy things, for instance, and they try and backdate assignments and things like that. But unfortunately, there's always a paper trail. So I've seen people get into a lot of trouble when they do this, because eventually you have a purchaser, for instance, that changes their mind and points this out as an issue. And then you've basically just committed fraud and tax evasion, because you just lied to SARS. So I wouldn't recommend doing any backdating. So unfortunately, this is one thing that hampers these type of sales. If the property is underneath the transfer duty threshold, different story. Then you can still get away with this. But provided it's above R1 million, paying transfer duty twice does impact the bottom line quite a bit. So the only other way to do this is just to do a back-to-back transfer. So I buy from X, I sell to you, and those are two transfers, and that is legit. You can do it at the same time, both register at the deeds office simultaneously. And typically you'll find that attorneys give discounts when it comes to doing this, because they won't charge you full price for both transfers. So that's the legitimate way of doing it. Another way of applying assignment or wholesaling is to basically broker the deal to somebody else. So you buy the property and then you find someone and you broker and you just take a commission from the deal. So they pay you out a com. The problem in that instance is if you're brokering, you need to be registered as an estate agent. And if you're not registered as an estate agent, you're technically committing a crime. And even beyond that, beyond committing a crime, the problem is that under the Property Practitioners Act, as it now is going to apply, the purchaser or the seller that pays you commission can actually claim that back from you if it turns out that you weren't properly registered at the time. So that also carries a level of risk. So the solution to this, I normally advise, is partner up with an agency, work with them, use certain referral agreements, and you can probably pull this off without having to do a double transfer.
Sure. Thanks, Bruno. Cilna, do you have anything that you want to add on to that as well?
No, definitely not. He doesn't have pop tires or key trucks, but it was perfect.
Well, wait for that.
I had fraud. I said fraud.
Exactly. I just wanted to say you gave me 2 moments to do this. So thank you.
Guys, I'm gonna quickly move on to the last question for the evening, and this one is it's actually been boggling me as well in terms of my thinking, and I want to find out, why do property investors use trusts? Because I mean the tax rate there is 45%. What's the benefit of using a trust? Cilna, what do you think about this?
Boggles my mind as well, Chris. I don't know why people are doing it. No. The thing about investment vehicles and investment structures for property is I hate it, and I don't easily use the word hate. Hate is a very strong term. I hate it when people try and sell, and I actually use the term sell here, investment vehicles and investment structures as a one-size-fits-all thing, especially if it is, as I just said, a selling thing. The moment you start investing in property, the next moment people will notice and they will run to you like banks when you enroll for a degree. They have now every credit card and every special and every deal you can think of. And the same with property investors. And the problem is, if you go to a one-size-fits-all sort of company to do your investment structure, you are probably going to miss the mark. And the reason why I say this is we invest for different reasons. Our why on investment is dramatically different from one person to the other. One person might just not want to be in corporate and have an everyday same job. They want to earn an income and live off the income while they are here. They are single, they are millennials, so they are planning to stay single forever, not really planning to have kids, whatever the case might be. Say I in front of, you know, and we are only millennials in this conversation, but and yet we have like actual kids and more commitments than we necessarily want. But the thing is, some people might want to invest because they want to leave a major inheritance for the kids and the grandkids and the great-grandkids. And the reason for investment is different. And this is the reason why your structure must be different. Because the truth about an investment structure is we're not only doing it for tax benefit, we're doing the planning around our investment vehicles with succession in mind as well. So this is the joy of us. And by us, I mean lawyers. The moment we start talking about anything, we pull death or divorce into it, and bam, we ruin a conversation. But succession is one of the biggest things that you need to consider when you consider investment vehicles. What do you want to happen to your money and your stuff when you die? Because I don't know how to break the news, but we're all gonna die at some stage. And we need to plan for that. I love to build an investment vehicle and an investment structure for somebody to suit their succession needs more than their right now while you are alive needs. Because The investor that wants to live off his money, he's anyway saying, you know what, if there's 59 cents left when I die, just donate it to the SPCA, and you know, that's all I want. I don't want to build money to last when I pass away. I have nobody to give it to, so I just want to live it off. Brilliant. Now we need to build something that's tax efficient for you right now, that can grow properly for in case you turn 120, and that's an easy way. And there's an easy way of doing that. But the guy with the family that has to put 3 kids through varsity, that has to make sure the one kid that's really not, you know, the brightest little star will be taken care of when the other 2 are well on their way, that person has to make sure that when he or she passes away, the kids are taken care of. So now we need to build something, and I like to use the term seamless succession. I love to say, when one of my clients pass away the day, I want them to be in a position where the family members can just cry properly, because you know, people need to cry at your funeral. They don't need to fight about money. So they need to know what's going on, and there shouldn't be a major expense on the heirs of the estate when you pass away. And that's why I call it seamless succession. So if you have a structure where you rather hold your property than in companies, but you have the shares of those companies held by a trust, then there is a trust, and there's a trust that comes in, but it only holds the shares of the companies. When the person then passes away, there is a trust, being a family trust, that carries on, and you don't have to transfer the properties, because either the directorship, there are agreements, and we know who the new directors will be if somebody passes away in the companies that holds the properties, and obviously the trustee will deal with the trustees and the follow-up trustees. It makes it really seamless. And you don't have to transfer properties. You don't have to do anything, because if that happens, it takes forever. I have very close friends who are stuck with parents that passed away 10, 12, 13 years after the parent passed away, and the estates are still not finalized. And the truth is, you can't really mourn and move on of a family member's passing if you constantly have to deal with the estate, because now you are constantly faced with their passing, and you don't want that. So now I took a whole new question that you didn't even ask, but succession and how you use the money from your property investment would be the 2 main things that we will have to consider when we set up an investment vehicle. Just before this, Bruno and I just quickly had this conversation, and we both say the riskiest thing that you can do in property investment is to believe there's a one size fits all. Don't take just what I mentioned, companies with the family trust holding the shares of the company as Cilna said that, so that is the answer. That is potentially not the answer for you. If you're not planning to have a family, that is totes not the answer for you. But very important is, if you hold property in a trust, you are going to make money from the property, and you are then going to be taxed at 45%. When a company, you're sitting on 28%. Now, full disclaimer, I'm not a tax expert in any way, shape, or form, but holding the property in a trust is in I want to say almost no circumstances, a very good idea. There are very few and far instances where I think it would make sense, but I don't like holding property in a trust. Doesn't make tax sense to me, and it doesn't actually make a lot of any sense to me. Bruno, help.
Cool. So I absolutely agree with you, Cilna. First of all, there is no one size fits all. Everything is very, very unique and tailor-made. The last time that we had this conversation, we kind of briefly touched on the different reasons why a trust is actually a really good vehicle to use in the structuring process, not necessarily in a vehicle on its own, but as a method or a means to an end, right? Now, if we now start focusing on the tax efficiency component of this estate planning, I typically divide this into two concepts. So you've got your long-term tax efficiency, your short-term tax efficiency. So a person's investment strategies and just their general life strategies would differentiate how you'd approach each one of these. So to give you an example, from a long-term planning perspective, right? Since we are all going to pass away, depending on the type of assets that we intend investing in, whether these appreciate very quickly, whether they in general of high value, which takes you beyond the rebate amounts, you might want to position these assets very specifically in a vehicle that doesn't get that exposure to SARS. So as a typical example, if you hold shares in a company, that falls within your estate. When you pass away, guess what? SARS is going to take money from you because SARS wants you to pay estate duty. And so if you look at the general calculation and how much estate duty you pay, which sits at around like 20% on anything above 3.5 million, and that's the lower end of it, you're paying a fortune to SARS. I mean, you can end up paying anything from 30% or 50% of your estate alone in estate duty, executors' fees, possibly capital gains because it's an appreciating asset. So from a long-term tax perspective, 45%, for example, 45% versus what you'll end up paying with SARS sometimes actually makes sense. But short-term tax perspective, you're not actually paying 45% in tax because obviously the people structuring this for you need to structure it in a way where you're not, where this is not a problem. You pay 45% tax in a trust. There's no question about that. That is the tax rate of a trust. It is one of the most expensive vehicles in South Africa. However, right, it's only an expensive vehicle if you're taking income into the trust and you're paying tax on it. So what's the solution to that? Don't take income into the trust. Either, for instance, own properties in a company that takes income into the company and tax is paid at the company level, or, for example, make use of some of the many tax principles or rules that we have where we move money through the trust, so not into the trust, but we completely bypass the trust and we move it into the hands of beneficiaries that don't pay high tax rates. And you can have it taxed in their hands. So if you do want to move money around in specific ways, you can completely bypass the 45%. And there's even tricks to that. People that get caught with properties in their trust, and now they don't have beneficiaries to move the money to. There's even other ways of actually being able to properly structure it. So I would not sit and worry that the trust is the most expensive tax vehicle, because if applied properly with the right advice, it actually isn't. Not at all.
And sure. I just want to throw in there, Bruno. I think you touched on something brilliant. Never, ever try to invest in property without a proper tax consultant. I think that's the answer, Bruno, because I've seen clients trying to do this, that, and the other, and eventually they get they end up paying loads and loads of tax. And a tax consultant would have just said, okay, just move it like, yeah, there and the other way. So never do this without a proper power team.
Yeah, absolutely.
Oh, God. This is my mind. My mind was boggled. You guys have just unboggled my mind. So thank you so much for that. So I wanted to ask you a question though. Can I put it in my will to say that everybody has to cry at my funeral? And if you don't cry at my funeral, I don't see tears come out your eyes, you were scratched off the wall and your portion will go to the SPCA. Can I do that?
I think, you know what, Chris, I think that's a little dramatic. What you can do though, is you can say, if I don't see crime, like proper tears, but not like proper crime, you're definitely not getting farewell tequila. You can definitely do that.
No, thank you so much, guys, though. I actually have a quote. Cilna, like while you were speaking, I took a quote down. I thought it was so poignant. It says, and I'm going to read it to you. It says, they will run to you like the banks when you enroll for a degree. By Cilna Steyn, circa 2021. That was priceless. But
I don't know if the banks are gonna hate me for that one, but you know.
Just jokes, just all jokes, but so lighthearted. Thank you so much, guys. Thank you to our viewers for tuning in this Wednesday. We look forward to seeing you next week. And please, guys, we urge you, ask the questions, drop them in the comments below, and ask them on the group itself. We're here to assist where we can. And thank you, Bruno. Thank you, Cilna. Guys, I know you're freezing, so go and warm up. And we'll see you next week.
Cool.
Cheers, everyone.
Thanks
Thanks so
everyone.
much. Cheers.
Bye.